Hello, good morning.
Good morning, sir.
How are you?
Good morning, sir.
Morning, sir.
Okay, so this should start.
Fine, sir.
We'll be starting my own section of jurisprudence and legal theory for your first semester. I hope that is understood.
Yes, sir.
Okay, now in starting this, what we normally will do is for last semester, we had just online classes. For this, for the previous year. Now, starting with you, we are going to have mixed physical and online classes. And for the mixed physical classes, the rules are already in place in terms of COVID protocols and all that. Now, for online classes, the first thing that you do is please at all times, you switch off your video and your microphone so that if you're in your rooms or in the classroom or wherever and you have to talk to someone, it doesn't disturb the class until you need to talk to the class. I hope we understand.
Yes, sir.
So at all times, you are supposed to switch off your microphone so we don't have any background noises and we can all concentrate on what we are doing here. Now, for this class, some of the topics I'll be teaching you will require that we do online classes and some we can handle physically. Because one of the things that online classes can assist us in doing is we can work with PowerPoint presentations and videos and all that. And other than that, it also gives you because you are going to have access to be able to download the whole lecture. So it also gives you the opportunity to be able to do a review. And it helps me as a lecturer to also do a review in terms of what we discussed and then what we can have. So we have it in that permanent format where we don't have to be scratching our heads to try to remember, since we have it in our computers and all that. So that is the reason why some of our topics we are going to go online to do them and some we can handle physically. Now for today, who is your class? Is your class rep in now?
Hey,
Mr. Theophilus, are you here? Okay, unfortunately, he's not here. I just wanted to compliment him on what he's done so far in trying to make sure that we are all at one with each other in terms of synchronize the three lecturers that will be handling. Mohib Aminat. Mohib Aminat. If your microphone is on, we've just had this discussion, please switch it off. Thank you. Now, for today's class, we'll start off by sharing a screen that basically there are two things that we're going to do for today's class. Today's class is introductory. Please, if you're having any issues in terms of hearing me or seeing me or the slide I'm going to be sharing with you now, just let me know. We can always find a way to do this without too many hiccups. Abdurrahman, Salman, please switch off your video. We don't want to see your room. Now, there are two things we are going to do for today's class. The first one is that it is introductory. And because it is introductory, we'll go through some general thoughts on jurisprudence. Then we will now go ahead to take a closer look at the things that we need to think about in terms of what jurisprudence is and how it situates us within this class in jurisprudence as a course and sometimes probably as a life form, because it's a system And I'm going to try as hard as I can to show you how functional jurisprudence can be, not just in Nigerian legal system or continental legal systems, but we are also going to take a look at jurisprudence in terms of how you can use it functionally as a law student, as a legal practitioner, and as you move forward. I hope we understand.
Yes, sir.
Okay, then after that, the next thing we'll do is just to scroll through the topics I'll be taking you for the semester. Those are the reasons why this particular lecture was important that we take online, because it will assist you in reviewing. For most of the things we'll be doing for the rest of the semester, my own section, you'll be able to go back to this particular video as a resource on your phone or on your laptop and make references in terms of the specifics that we'll be doing for the rest of the semester. Now, I'll go to my slide so that we don't stray too much away from the path and we can focus from the get-go. I'll be sharing this slide with you. Please, again, if you can't see the slide or there's any issue, let me know. Can you see the slide?
Yes, sir.
Okay,
Yes, sir.
fantastic. So one of the things we wanted to talk about was to focus on exactly when we talk about jurisprudence and legal theory, exactly what do we mean? Can someone assist us with that? When we talk
Hello,
about
sir. Good morning.
jurisprudence and legal theory, what do we mean? Okay, go on.
Thank you, sir. When we talk about jurisprudence, we are trying to examine the and how it's used in social engineering.
Okay. Somebody else. Social engineering, he said. Somebody else.
Hello, sir.
Okay, go on.
Yes, jurisprudence. Basically, we want to examine various thoughts about law and how useful it is in society.
Okay. Someone else? Various thoughts about law, how useful it is, purpose, and its role in the society. Someone.
Yeah, good morning, sir.
Good morning, Tunji. How are you?
Fine, sir. Yeah, my own definition of or meaning of jurisprudence is the study of the theoretical aspect of the law, sir.
The study of the theoretical aspect of the law. Okay, we'll stop there. Now we have about 3 or 4 basic definitions that encompass everything basically that jurisprudence is about. They are not the same definitions, they are all different definitions, but they are all, each one is a component of what we do when we are studying something that we call jurisprudence and legal theory. But let me try to look at it from a perspective that is simple. Now, when you say jurisprudence and legal theory, there are certain things as a law student that come to your mind. Number one, do you call something jurisprudence and at the same time legal theory? Are they the same phrases? Do they mean the same thing? Are they repetitive? If you say something is theory, does it presuppose that jurisprudence is somehow different from legal theory? And the reason we are having these kinds of discussions is for you to be able to understand jurisprudence. I think jurisprudence and legal theory itself may escape an all-encompassing definition. If you've spoken with Professor Egbele, I'm sure he probably would have talked to you about the fact that jurisprudence, that Professor Okuniga said nobody understood jurisprudence, right?
Yes, sir.
Yes, sir.
And that
Yes,
nobody
sir.
can engage in a study of all studies or have a definition of all definitions that encompasses law. And then we are talking about jurisprudence, which is supposed to be the science, almost scientific study of law. And we can't even define exactly what law itself is. So how can you define exactly what jurisprudence itself is? But some of the things that we'll be discussing will be to the effect that even if we have a problem in terms of definition, we are going to have, each of us is going to have a working, I call it a working definition because it may not be perfect in itself. Each of us is going to have a working definition of what he thinks the law is, first of all, and then what he thinks jurisprudence and legal theory is, and how those two things interact with, how those two elements interact with each other. I hope we are still on the same page so far, because we've not even started on page one.
Yes, sir.
Yes, sir.
Yes, sir. Yes, sir.
Okay. Now I want us to focus more on the slides. So I'm going to go to the first slide and what it says. Somebody called Sting sang a song, Shape of My Heart, and he said, the hidden loss of a probable outcome. It was just a phrase in a sentence in the song. The hidden loss of a probable outcome. How does that relate to jurisprudence in terms of definition, if we are trying to define jurisprudence and legal theory? What do you think? Are we thinking, or I should assume that we gave up?
Yeah, thinking, sir.
We are actually thinking.
Okay, think very hard.
You didn't know.
Now, when we talk about the hidden loss of a probable outcome, for me, it summarizes exactly what students is striving to do. It talks about the hidden loss. We have hidden rules, hidden scientific ways of doing things. But traditionally, law has never been seen as a science. And because of that, the outcome is almost always probable based on different things. It could be based on the preponderance of evidence. It could be based on the law itself, the statutes that are in question and that touch on the particular facts of a particular case. It could be based on somebody's ideology, like members of the realist school say. It could be based on somebody's ideology. It could even be based on what a judge ate in the morning. It could be based on the lawyer's idea of how he brings out the components or the elements of facts as explained to him in his law firm by his client. So because of that, even though we would like to look at law as something that is surgical with some level of precision, where you can, A can be, when you plus A plus B, it can lead to C or whatever. We have seen that that is not necessarily the case with law. Now, the job of jurisprudence there is to limit these improbabilities so that we can have a clearer understanding of what the law is. Which is why a lot of people call jurisprudence the science of law. That is what we are trying to study. Now, when you are trying to do this, there are certain things that have to come into play. One of the things that has to come into play is in your head, how you organize thinking. You keep disturbing us. You try it one more time, I'll expel you from the class. Listen to instructions. Switch off your phone. Switch off your microphone. Now, we said, how do you organize your thinking? If you are trying to organize your thinking within the confines of jurisprudence and to be able to arrive at something that is subservient to the evidence that you have before you, not just something that's discretionary. It is founded upon specific things before you. Then it means your thinking has to be organized in a way that makes sense. I hope you understand what I'm saying.
Yes, sir.
Yes, sir.
Because if you are thinking in a very disorganized way, then your resolution, the final result, will also be disorganized. So what we try to do in jurisprudence is to be able to think in an organized manner where you can have specific outcomes from your endeavor, which must also be done in a specific manner. I hope we understand all this. Now, the thing is, what you do in jurisprudence, we've not been able to define jurisprudence, and for some funny reason, we've not even made much of an attempt. But what I want to focus on first is think about what you do with jurisprudence. Then perhaps that will lead us to some kind of workable definition. Now, one of the main things that you do with jurisprudence and legal theory is what you call critical thinking. Critical thinking is absolutely essential because we live in a world that is suffused with thoughts, with ideology, with theories. And sometimes when we see things that are practical, that are happening, we try to isolate that from the philosophy. If you see, for example, that in South Africa, there's an understanding there that the LGBTQ rights are absolutely important in terms of both their legal system and their social life, then you have to ask yourself, why? How did they come to that result that is at variance with most, that the same result is at variance with the results that most African countries came to? And then you think in terms of apartheid, where there was restriction, a lack of freedom. So you can have an understanding where someone now comes and says, okay, we are increasing freedom. We are trying to make freedoms as limitless as possible. But when we talk about critical thinking, the first thing that must come to your mind as a student is that every thinking that you do should be a problem-solving endeavor. You are trying to solve a problem. Now, if you are trying to solve a problem, it means that your thinking must be organized in a specific manner. When I talked about something being subservient to the evidence before you, you as a person and as a thinker will almost always have to be morally neutral. Being morally neutral means that you don't bring your politics or your religion or your culture or whatever into the thinking that you have to do. Why? Because you now will not be responsible for the results of that thinking. So when we talk about, and that basically leads us to what we call syllogism. Let me give you one example. Nigerians are crazy. If we say Nigerians are crazy, or if you are a Nigerian, what are you? Can someone answer me?
You're a crazy being, sir.
I'm crazy.
You're
I'm
a crazy
crazy.
person, right?
Yes, sir.
So, Muktari Tudai, my humble self, is my name. Where do I come from? I come from Nigeria. The natural consequence of coming from Nigeria means that I have that I'm crazy.
Yes, sir.
Whoever said that is in trouble.
That is
For
funny.
agreeing with me that I'm crazy, you are going to pay something back. Now, that is what you call syllogism. Because you come from a very large premise, and then every other little thing situates itself into that premise. And it is also because of that that we can come out with things that we say are theories. This one is a theory, that one is not a theory. But when you do syllogism, always understand that there are evidence, there are arguments, there are thoughts that are involved, and those thoughts must be subservient to evidence. Now, if you look at a lot of postings on WhatsApp and things like that, somebody will say, A, B, C, my wife is fantastic, she's wonderful, in fact, she has always been a good mother to my children, this, and that. What is the result of all that? We are getting a divorce tomorrow. That is an illogical syllogism. Because what we try to do is to arrive at something that is subservient to evidence. So what he was doing is, if it was subservient to evidence, then they will not be divorcing. That shouldn't be the result or the finding. I hope we understand that.
Yes, sir.
So a lot of times we say things without thinking, but as students of law, every sentence you utter is important. It makes a difference. Every detail has to be taken care of by you. And I'll tell you one saying now. I always say this: for law, the devil is in the details. If you have a 400-page document to read, you have to read those 400-page documents. Because that one paragraph that you do not read is what is going to be the devil. So, we talk about subservient, you have to be subservient to evidence, then you have to arrive at conclusions from a solid or good or true premise. Your conclusion has to be based on evidence. Why? Because if you are in court, for example, the judge's conclusion will be based on evidence. So as a scholar, your conclusion must always arise out of your logical thinking and analysis. And we normally will say that argument is an analysis of a fact, a state of things, a law, an opinion, whatever. You have those arguments, and they are absolutely crucial for the job of a legal practitioner, because one argument invariably leads to another argument. Now, let me hypothesize that with Nigerians are crazy. If you ask someone, A will say Nigerians are behind other countries. What's the reason? He says it is because Nigerians are crazy. So there are arguments there. Number one, what does crazy mean? If you are lucky enough to find out what crazy means, then you have to ask yourself, what does behind means? What does other countries mean? Who is a Nigerian in the first place? Did you think that there will be this much argument in that statement?
No.
There are even more arguments there. Because when you talk about who is a Nigerian and who is not a Nigerian, you have to go now into the Constitution to find out the sections that relate to citizenship, and then whether your father or your grandmother or whoever was born before January 1960 and all that. What makes you a Nigerian by birth? What makes you a Nigerian by naturalization or whatever? And if you are not a Nigerian by birth, but a Nigerian by naturalization, what are you entitled to as a citizen? So this is the nature of this course that you are doing, jurisprudence and legal theory, where one argument opens up another argument, and that argument opens up another one. And I always tell you as scholars here that there isn't a yes or no answer to any question in jurisprudence and legal theory. Very much different from other courses, for example, like constitutional law, law of evidence, or law of contract. Our job here is argument. So your perspective is very important, but your conclusion is your conclusion. So as your so-called lecturer, nothing I say is the truth. You look at it from the perspective that everything I say is from my own perspective. And there's a Samuel and Duncanson said something, which is that when you use jurisprudence to try to analyze and take a look at what law is and all that, and then in the process, you are beginning to write theories. What are theories? Theories are basically what you think may be universal truths relating to a particular topic or a particular subject. So when someone, for example, says, what is law? And Jeremy Bentham says, law is anything that is enacted by the legislature. In itself, that's a theory. So you look at the theory to ask yourself, does this theory work? Is it functional? Or is it something that one set of facts can destroy at the first reading? Does it work? So we'll go through some of that. Now, there are three basic things that we look at in jurisprudence when we are trying to study law. A lot of these things will probably repeat when it is time for you to study the schools of jurisprudence in during your second semester, because that is when the real philosophical and legal theory of jurisprudence will come into play. The way your curriculum for the year was designed was to make sure that in the first semester, some of the things you taught will have relationships with what you have learned before. So for example, I'll be taking you sources of law, and in sources of law, you're going to be learning some things that have touched on other things before, like I'm sure you've done customary law in legal system, right? Hello? Who is going to answer me? Hello?
Yes, sir.
Hello, sir.
Hello, sir.
We are with you, sir.
Are you guys online,
Hello,
first
sir.
and foremost?
We can hear you.
Okay, Sharifat. Hello?
Hello, sir.
Are you hearing me?
Sir?
Yes, I hear you
Yes,
now.
sir. We are
Yes,
with
sir.
you, sir.
Was
Yeah,
there ever
yes,
a
sir.
time I went offline? I don't think so.
No, it's the
Yes,
network, sir.
yes,
It
it
was
is
the
network.
network,
We
sir.
couldn't hear you earlier, but you can hear you now.
Okay, okay. But I hope you were able to follow the track of what we were saying.
Yes, sir.
Yes, sir.
Yeah.
Yes, sir.
It was
Okay.
just like for some seconds.
Okay.
We didn't get it out.
We didn't get it, oh.
Okay, what didn't you get? That's another question now.
The beginning of
When we
nature
were
of
about
law.
talking about source of law.
No, we've not even talked about we've not started discussing the basic nature of law. Now, we were talking about critical thinking before, and I told you the most important thing is problem solving. For you to solve problem, there's something called syllogism, which is moving from some kind of main premise to some specifics. And then if you get to those specific things, it means that everything specific must be able to be come within that main premise. When we talked about Nigerians, for example, are crazy, and I said, my name is Mutari Tudai, I'm a Nigerian, then it must follow that I'm crazy, right?
Yes, sir.
Somebody keeps saying yes, sir, when I say I'm crazy.
Ah,
Okay, so
We are not, sir.
that's Abdul Salam Abdulaziz, sir. That's it.
okay, you want to really get him into trouble. So we said everything we also say must be subservient to evidence, and that you must arrive at your conclusions from a solid, good or true premise. And then beliefs reached on the basis of good or bad reason have very dangerous effects. If you get to, then again, we talked about the importance of arguments. And I said what we do in jurisprudence is basically to argue, because there are no yes or no answers to anything. What you have is a perspective. Your perspective can be solid, it can be weak, depending on how it faces up to the arguments of other colleagues or other scholars. Okay? Are you with me?
Yes, sir.
Yes, we are with
Yes,
you.
sir.
Okay, now there are three basic ways that you try to organize your thinking in jurisprudence and legal theory. One of them is to understand the nature of things. If we say, I'm a man, the first thing you want to understand is what is the nature of a man. Then you study it from different perspectives. There are, despite the attempt to negate gender across the world, across Europe particularly, a man is basically seen as a man if he has private organs that denote what a man should have, right?
Very well.
So that is part of the nature of a man. It could also mean that if a man has certain chromosomes, if he has the Y chromosome, then he can be seen as a man. There are other things that make you a man, right? That not just medical, but even things that are social. For example, you see a man in terms of being a protector of his family. You see him in terms of being a provider for his family. So all those things are things that culminate into what the nature of a man is. So when you talk about law, which is what you are we are talking about the science of law now, you also want to look at law in terms of what is the nature of law. Now, we'll go into the second one, but let's go through this first. We said this was at first conceptualized by Plato and Aristotle, who were great thinkers, and they seem to embrace the nature of law from the precepts of not only enacted law, but that of prescriptions and customs. Now, as a good student, you go down to look at what prescriptions is. Prescriptions is what you call basically you look at it from a perspective of private customary law. So they are talking about agreements over time with groups of people, with individuals, with families, whatever. Those are the things you call prescriptions. And then customs. And we said most of the controversy about the meaning of law came to center around the distinction between law and morality. As Professor Egwele started teaching you on, did he discuss law and morality with you? Because he's going to take you that this semester, I believe.
No.
It does not.
Okay, not yet, right? You will see,
Yes.
one of the main arguments in jurisprudence is what is law, what is morality? Which one predates the other? Which one comes before the other? Does morality give law validity? What are the differences, the characteristics of law in terms of administration? What are the differences in the characteristics of morality because of administration or any other thing? Are people more obedient to law or more obedient to morality? So there are certain characteristics, for example, of law. And we say it is characteristic of law to be enacted, and it resides specifically in the public domain, while morality resides in your mind. Your sense of morality is different from what the law says. And two, many rules of morality are not suitable for enforcement. Who can tell me a rule of morality that may be impossible to enforce? Hello?
Hello, sir.
Tell me a rule of morality that you think to enforce.
Hello, sir.
Yes, sir. Although it is care for one another, but that may be fault because we may not be in a position to always care for.
Sorry, Morina, we are not hearing you well. Could you raise your voice?
Can you hear me now, sir? This is
okay, yeah.
Yes, sir. What I said was it is a rule of morality or morals that we should care for one another, but we may not always be in a position to do that. And it will be difficult to enact it as a law that you must care for one another.
Thank you very much. That was a fantastic example. In fact, I was thinking in terms of respecting your father for one, which may be a rule of morality, but can more or less not be enforced because of certain reasons. Number one, it's rough in terms of whether you can have a specific law that states it. And what is disrespect to one person can be respect to somebody else. There are all kinds of variables that come in terms of whether certain laws can be enforced. And what you call disrespect could just be the way you look at someone. And he says, I don't like the way you looked at me. And you ask him, how did I look at you? You understand? So, but now we say both of these can overlap. Both law and morality can overlap. And when they do, it can lead to certain consequences. So the distinction between law and morality can permeate some indices of legal order. What we are trying to say there is there are certain indicators that can tell you how to distinguish between law and morality. Number one is its foundation in public acceptance. Do the public accept this? Because you have a general understanding. Respect of your father, for example, or taking care of someone are rules of morality that traverse the whole of the country, if not the whole of the world. So the question is, it's general. It is founded upon public acceptance. but the law may not necessarily be founded upon public acceptance. Professor Ijalaye talked about the bush burning laws in Ondo State. He was former Attorney General of the state, and he talked about the bush burning laws. And a certain number of years of imprisonment if you burn a bush, set fire to a bush without a permit and all that. And people went around burning bushes without any inhibition whatsoever. Why? Because the hunters will burn bush so that the rats and bush animals they kill will come out from their holes because of the heat and all that. And in the process, set a farm on fire, you know, but it didn't have public acceptance. Why? For economic reasons and for political and other social reasons. Now, that's the public accept. And two, the manner of its construction and administration. We talked about respecting someone, but there are no words to specifically tell you what respect is and what elements you get that you can use as elements of the crime of disrespect in a court, for example. And then we talked about its eternal purpose. Its eternal purpose basically means, what is the purpose of this particular thing? If we talk about morality, for example, we'll be talking about being able to take care of your father, respecting your father, try to maintain your family, whether it's nuclear or extended, and then some other things. Now, the question is, what is the purpose? The purpose of some other laws could just be to make money for government to raise revenue. Like a lot of these bylaws that local governments make, where if you are crossing a place, somebody can just throw a stick in front of you to stop you, and they say, unless you pay so amount of money. You could have a bylaw just to make revenue, or some other laws to organize people and all that. So the purpose is also important. And you realize that most of the time, the purpose of morality has some kind of divine hope in terms of what is going to happen to you when you leave this world. While a lot of the things in law, legislation specifically, may be focused on what happens to you while you are here. The reason you pay your tax maybe is not because you want to go to heaven, it's because you don't want to go to jail. The reason you will respect your father and your mother will not be because you do not want to go to jail, but because you do not want to go to hell. I hope we are understanding.
Yes.
Yes, sir.
So because of that, people see law as being a power. And if it's a power, it's a fantastically humongous power. Because, and I'll tell you this, usually because religious people also have the same type of power that law has, law, judges, lawyers, you find out that each time there are revolutions, you look at the Russian Revolution, the Bolsheviks and all that, you also look at the French Revolution. Once they take care of the royal family, the next people they follow are the priests and the pastors and the religious people. The next people are the lawyers and the judges. Because basically you form an establishment that has been all powerful against the common citizens of the country. Now, if we now say law is a power, it means that there must be rules. So that that power does not descend into the vagaries of somebody's discretion and the whims and caprices of one person sitting on his own. And we say those rules must be enacted. They must be prospective in action. It means you are not making a rule for what happened 2 days ago. You are making a rule in an anticipatory manner for something that is going to happen or currently happening. But those rules must not be attached to specific people or groups. It must be general rules. You can't make a law that says Mutare Tudae cannot marry, Mutare Tudae must marry under the Marriage Act. Because that law will be specific to me. But if it is generalized that all lawyers or all lecturers must be married under the Marriage Act, that's a different thing entirely. And then it must be understandable. And this is sometimes where law fails. In terms of how we write hereunto, whereto, for, herein, under. And because of that, you have something that in the US for a long time, they had something they called the plain language movement, which was a movement to show that law can be drafted in simple language that the common man can understand. And outside of all that, we also say that governmental action must be consistent with sanctions as punishment or deterrent for contravention of the enacted rules. If you have a government that does not follow its own, and when I mean government, I mean the three arms of government together, not just the executive, that does not follow the rules that have been laid down and their actions are not consistent with those rules, then you can't say that you have law functioning in that country. I hope you understood.
Yes, yes, sir.
Okay, now we talked about things. We tried to talk about the nature, right? First thing we said was an indicator for how you should think in jurisprudence was to understand the nature of things. The second thing is to understand the application of those things. The third one is to understand the eternal purpose. What is the purpose of these things? And perhaps sometimes you can start from the beginning and end somewhere. And then in ending somewhere, that end brings you right back to the beginning. And that is the way this three tripod works. You understand the nature of things. You understand the application, how you use that understanding of your nature to apply that things to things that are physical, things that are seen, not theories. And then what is the purpose of that particular thing? Why did we make this law that talked about bush burning? What is the nature of that law? How do we apply it? Who are we applying it? Who are the people that bush burn? Is it the professor in University of Ilorin?
Is that a question?
It's a question, if you can answer it.
The hunters.
The hunters. The hunters are the ones that burn bush. And we were talking about things, and let me bring it to a much more banal and simple level. We talked about when someone was talking about the administration of justice act. And they wanted to infuse plea bargain, which has basically been infused now. They wanted to infuse plea bargaining into it. And people say, and my question was, who is plea bargaining important for?
The accused.
The accused person.
Who is the accused? What class of accused person is plea bargaining important for?
An accomplice. Yes, sir.
The who?
The noble people, the people that are wealthy.
Thank you. Because the man that steals goat at Ojaoba and they get him and put a tie around his neck and set him on fire. He's not interested. He does not even know there's something called plea bargaining.
It is only those people who are influential.
And then our understanding of plea bargaining fails all the rules of logic in terms of what are the punishment theories. Are you trying to deter other people from doing it? If you are trying to deter other people from doing it, why would somebody pilfer the treasury and take 10 billion and you say, okay, bring 3 billion and then you can go away and sin no more? That's some kind of rehabilitation, which is supposedly a punishment theory. Is it education? What is it? What are you trying to achieve by telling someone to steal and then you make a deal with him? And in doing some of these things, when we talk about inquiry, it means that when we are talking about plea bargaining in Nigeria, we have to understand what plea bargaining is in the US, in the UK, in Portugal, in South Africa, wherever. Because plea bargaining was originally what they call the whistleblower laws. Whistleblower means 5 of us sat down and we planned a crime. For the remaining 4 people, for example, to be prosecuted, you need someone inside who can say, we planned this thing, we planned it on so-so and so-so and so-so and so-so day. And that is when you do what you call it, under those kinds of circumstances that you do plea bargaining. Not that this person that is selling his cohorts will go free, but that he'll be given a lesser sentence so that he can give evidence, because without his evidence, you cannot even convict the other 4 people.
Hello, Carol.
Bolaji Sadiq, I hope that's not you disturbing our class. Now, I hope I'm still with you.
Yes, sir.
Yes, sir.
Okay, so when you talk about plea bargaining, when anybody talks about any kind of law, your job as a lawyer, as a student, as someone within the Nigerian, somebody who has an interest in the Nigerian legal system, is to look at it, analyze it, look at the nature of this thing they are talking about, look at how it will be applied, and ask yourself, what is the purpose of this law? That is why you are here studying jurisprudence. Because you are in constant inquiry, you are questioning. And there are schools, the critical legal studies movement will tell you that all the laws that you are seeing being made by legislatures are to protect the interests of a political or an economic clique in the society. And that if you seriously analyze these rules, these regulations, these laws, you will realize that they are there to protect specific people. Take, for example, we all think that laws against theft and burglary and all that protect all of us, right?
Yes.
Yes.
Tunji, what is the most expensive thing you have in your hostel, inside your room?
My laptop, sir.
How much do you think it's worth?
Maybe 210,000, sir.
Okay. Now, I don't think somebody is going to hold guns and submachine guns to come and steal your laptop.
They wouldn't want to do that, sir.
He said they wouldn't want to do that. Do you have some charms in the room?
No, sir.
Sorry,
Okay. Thank you for telling us. We'll be paying you a visit very soon. Now, when people go out and they say we are trying to get something, they are looking for people who have something. So while the laws regarding theft and burglary and all that may protect all of us, it protects some people to a higher degree than others. Some years ago, armed robbers came into my house. I'm sure they were misguided. Some idiot must have told them that man has money. They entered my house. They didn't see a dime. And I think just they decided to take the car. So my thinking is, okay, if I did not have a car, it would mean that the laws relating to burglary, theft, and all those things may in fact not even apply to me because I have nothing that is worthy of being stolen. Who are the people that have things that are worthy of being stolen? The people who have boxes of dollars in their houses. People who buy a golden jewelry for 5-10 million. And the critical legal studies movement said those are the people that that law works for. And in Islamic, in the Sharia, for example, if somebody is going through your farm and he's hungry, he's probably entitled to take a corn or something to take care of his hunger. And I think he's protected under Islamic law.
Yes, sir.
Yes.
But our legislators do not protect you from dying. Why do you think that is the case? They don't say, oh, this man was about to die. That was why he broke into this man's house to eat. They just sentence you. So there are a lot of thinking that we'll be doing during the course of the year that I think will be very important with you. Now, there are 4 basic areas of inquiry and in jurisprudence. Now, again, we'll go through all this before we start the schools of jurisprudence so that they can act as a foundation for your thinking. In terms of when you talk about a particular school, what are the things you are looking for? Now, but that will be in the second semester. Now, there's something they call the analytical matter of jurisprudence, where you're analyzing infrastructures. What are infrastructures? Infrastructure is the judicial system itself, the court system, the prison system, the police system, how lawyers work in their chambers. Then you also take a closer look at subject matters. When you talk about law, when you talk about criminal law, what are you talking about? When you talk about civil law, what are you talking about? Electoral law, all those things, what are you talking about? Then you look at legal precepts and principles. When someone says nemo judex in causa sua, what does it mean? Audio alterem patem rule. So you look at that, and then there's also the sociological matter, and this is where jurisprudence is so much more important than any other course you'll be taking during the course of your stay here. Because you are looking at not just the science of law, you're also looking at the sociology of law. How do you study law looking at your society? And you look at law in a functional manner as an instrument of social change, especially for people in developing countries that require that. And that's why when we're talking about the sources of law and we go into interpretation of statutes, we'll be having a little discussion on whether we should be interpreting our statutes the way the Americans or people in Europe interpret their statutes. Should we be putting more emphasis on developmental elements in statutes? Why? Because obviously we are a developing country, so we should be focused on what develops us.
See online, we can send messages several times. No? Okay, one more time.
Then we also look at the study of the development of law and social systems. Because, you know, like we talked about plea bargaining now, we have to look at the development of law in other countries when we talk about our own country, so that somebody cannot use wool to cover your eyes and be telling you that you need what you do not need. And making laws to protect 2 people out of 200 million people. And why that is important is that as law students and as the future of the Nigerian legal system, you are at the vanguard of this discussion. Then again, people kind of treat law as a consciousness and a philosophy. When you look at what we now call African law, what is the main philosophy behind African law? What do you think is the main philosophy behind what you call African law? And I'm talking about our customary law, our traditional practices and usages.
Social standards, sir.
Social standards, okay. What else?
Religious standards.
Well, yeah, social standards, we had religious standards, we had all that. But now let's look at it specifically. If there is conflict between 2 individuals, it could be a criminal conflict, it could be a civil conflict. How was it resolved? With what sense, with what spirit?
Morality?
Yeah, morality is part of it. But I think a greater spirit will be the spirit of reconciliation.
Yes.
Okay.
The spirit of reconciliation, in the sense, let me give you an example of what happens even in the modern Nigeria that we have now. You are going there, you are a rich man with your, what's an expensive car nowadays? Well, any new car is an expensive car, right? So you are going around, driving around in your expensive car, a keke napep hits your bumper. And you come out and you say, you, this man, why did you hit my car and all that? And there are people who saw that he hit your car. And you find somebody coming and saying, nah, please forgive him. He was not looking. He didn't know what he was doing, this, and that. Why? The objective is to reconcile both of you so that each person can go on his own way. If what you do as a rich man is to pay for the bumper, you can handle it. What this poor man does is that he does not have any, he probably does not have money to pay for the bumper of your car, but he can leave the place a little more penitent and more subdued. And society thinks that is better because it reconciles you in the process. Tomorrow, if he sees you, he will greet you. You have not fought. And you, as the rich man, you are insisting on calling police and saying you must do this, you must do that. He was doing reckless driving. I'm going to make sure he goes to jail and what, which were within your rights. But within the confines of African law, the objective was always to reconcile people. It is now then that you'll be looking for witnesses to show that he drove recklessly and hit your vehicle. Do you think in Nigeria you get any witness?
You not get to.
They will tell you they did. The people who were saying this man was driving recklessly, we saw that he's very sorry. Please just leave him. God will provide for you to take care of your car. All of them will say they didn't see it. They didn't see the accident. So the objective was reconciliation, not the destruction of citizens. Which is why you find out in Nigeria today that even within our so-called English inherited legal system, you find the reluctance of people to punish harshly as the law says. The reluctance of judges, the reluctance of policemen, the reluctance of prosecutors, the reluctance of lawyers. And because of that, our interaction with law is different from the interaction that other continents have with law. Because here we empathize with our criminals, sometimes to the detriment of our victims. I hope we're together.
Yes, sir.
Yes, sir.
Okay, so we said and that is consciousness. Now, if your consciousness is at variance with the specific laws in your statutes, then it means obviously jurisprudence has work to do because it has to resolve that conflict. That should be your thinking for the future and now. So for this introductory section, we talk about what are some thoughts of the law that you have. We've talked about your understanding of what is law. It is a thinking that you must have. What are the elements or components of law? For you to be able to understand what is law, you are looking at what are the elements or components of law, and we talked about some of them within a legislation criteria in terms of the law must be enacted, it must be anticipatory, it must be understandable, it must be this, it must be that. And we went ahead and added something, which is that governmental behavior must be in consonance with the laws that have been enacted and all that. But when we're talking about it must be enacted, it must be this, it must be that, we're not even talking about in terms of conventions, for example. We were not talking in terms of customary law, which is not necessary, which is not enacted. And they are still law forms. So when we ask ourselves, what are the components? If we think of customary law as law, then what we think are the elements or components of law must encompass not just legislation, but also customary law. And if we think constitutional conventions are laws too, it must encompass those. And what is the science of law? We talk about jurisprudence and legal theory as being the science of law because that is the only course you are going to find in law that goes outside of the law to study law. And while that may be a little, how do we call it? It can be abstract in terms of thinking. But you are not going to find any legislative house that does not have jurisprudence experts looking at legislation. If there's a law review function, a law enactment function or whatever, you must have people in jurisprudence who are going to be there to set the tone for that discussion. Why? Because if you do not have a philosophy of what you want to do, then you have not started doing that thing. It's like marriage, for example. If you don't have a philosophy as to what marriage is, I will advise you not to just go and marry. Be as single as you can be until you have a philosophy as to what marriage is and what your place is. How do you situate yourself within that marriage, the marriage system? Because there will be some things that will just be antagonistic to the whole principle of marriage. I hope we are okay.
Hallelujah.
Yes, sir, we are.
Okay.
We are
Okay. Now, and we said, what is the science of law? If this is the science of law, how do you study law? The way we study law has changed over the years. We are having an online class now. Before then, people were talking about don't give notes to students anymore. Have PowerPoint presentations where you just have headings so that the students can generate their own thoughts. And that makes you a partner in this process. The teacher is as much a student as the student can be a teacher. Because if the question is what is law alone on the board, then we have more interaction than if I bring a note to you and I'm dictating. There you stop thinking and you just listen. Now, there's something called the Bloom's taxonomy. We talked about the different layers of intelligence and studying and what you need to do. The first layer, it says, is just to basically memorize. It's just the word, you see. Then 2, to understand. 3, to analyze. 4, to blah, 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 and they themselves changed the way you study some years back to include that you should create with what you are studying. Why? Because all the Bill Gates and the Steve Jobs and the whoever probably dropped out of school because they couldn't create within the educational system at the time. And they went to find ways of turning calculators into computers and having softwares and all that stuff. So the best people, the most creative people, found it difficult to stay within the confines of your traditional educational system. Now, that is why we say when you are trying to study this, the way you must look at it must be, how do I use this knowledge to create something, to create thoughts? And again, what is your relationship between your understanding of law and your choice of law as a profession? Can 2 people just give me answers? What is your relationship? Why did you want to study law?
Yes, sir. I wanted to study law, particularly from the perspective of international law and human rights. That is, to understand the workings behind human rights, particularly human rights within the framework of Nigeria, and why it is so existent and not taken as seriously, and then also its interactions with international law.
Okay, fantastic. Another one. Nobody else knows why he wanted to study law.
Yes, sir.
Go on, why?
I want to study law because I want to deal with family affairs, something related to divorce, to reduce the divorce cases, and something related to anything concerning families, including the inheritance, that is the intestate and intestate properties, anything related to family. That's why I want to study law.
Okay,
And
let me go to another question. Why is family law so important to you? If it's too personal to you, don't tell us.
okay. It is so important to me because of what is going on in the contemporary era now. Because it seems the new marriages as at now are now broken at early stage. The divorce rate it keeps increasing day by day, and that's what brings passion. That's why I have interest in it.
Thank you very much. Now, these are the kind of things that are good to hear from you, because sometimes when you look, take family law, for example, and it's very important that we understand why we want to do what we are doing. If you take family law, you look at Now, there are studies to show that most of the people that are in the criminal penal system, you find out that anything between 70 to 80% of them come from broken homes. Where as children, the parents broke up, and then the children, thinking that they were smart, were playing both parents together. And because of that, there wasn't any social stability in their lives, no education. Well, you could have education, but very little social stability in terms of disciplining, in terms of mentoring and all that. And that goes straight to the point of having a larger social stability. So for you, we could think of you in terms of, okay, this is someone who is also focused on maintaining social stability in Nigeria, because a lot of the things you see now, banditry, people engaging in kidnapping, religious extremism, and all that, can come right down to families.
Yes, sir.
So now the question is this: how come somebody has not just told me, I wanted to study law because I had lawyers make money?
Maybe they don't want to say it, sir. Some of them said it at the last class.
Yes, sir.
Okay, I mean, that it's noble to want to make money. There's nothing wrong in wanting to make money, but you probably make more money as somebody doing buying and selling from the get-go than paying all this money to be a lawyer in a school. So,
especially when you say lion.
Thank you. So for lawyers, you must have higher ideals, of which making money becomes a consequence of that ideal. It could be an ideal of justice. It could be someone, I mean, Ganifa, for example, had this idea of enriching our legal system through social change values. Not just social change values, but also creating a very large corpus of published work for the use of the legal system. And he was, obviously, you know, he was one of our foremost human rights lawyers. And he also he became rich and known for areas in law that hitherto people did not take seriously as a way that you could be rich in. Now, when we have an understanding of why we are doing things, and that's the job of jurisprudence, because what we are trying to do is so that you can think in an organized, logical, sequential manner. The moment you are able to do that, then you are able to arrive at a place where you can start evolving philosophies. It could be a philosophy of life. It could be a philosophy of God knows what. In dentistry, there are also there's jurisprudence in dentistry, for example. If your teeth has problem, are we focused on reducing the pain by removing the teeth, or should we be focused on aesthetics by leaving the tooth there? That is a philosophy. That is something that arises out of jurisprudence. If they may not call it dental jurisprudence, it may not have a name, but it is jurisprudence. Because they are evolving a philosophy of dealing with a particular problem. So we ask ourselves, if we are interpreting law in a developing country, like I told you, my thinking is always that law should have developmental components when you're interpreting. This thing I'm interpreting, how does it make this country better? Because as you find out when we do interpretation of statutes, judges have those latitudes in terms of discretions that can be used. Then we also ask ourselves, this jurisprudence that we are studying, jurisprudence and legal theory, what must it do? we can look at jurisprudence as an ideology, for example. It means we have to evolve an ideology. If the original African law was focused on reconciliation, and now we are focused on punishment, that it means that unless the people have changed over time to focus more on punishment, it means that there's a variation between what we are focused on in our current English inherited laws and what our philosophy of life is. When we talk about morality, obviously cases like I think Edet and Essien, Daudu and Damole and all that, you can see that there was placement of social stability above individual rights. Is that a philosophy? If it's a philosophy, then as scholars, we must be able to isolate that philosophy and say, this is the philosophy we have. And then every other thing, our lawmaking function, the type of laws we come with, our administrative functions, financial functions, compensatory issues, everything will have to be in line with those philosophies. Because if it is not, then we have serious issues with compliance. So, jurisprudence tries to teach you to evolve ideologies. 2, jurisprudence is like a heritage. It's like the old stories of how to solve problems that your grandfather told to your father and your father told to you, and then that you will tell to your children. There must be a chain in that use of knowledge and its dispensation. One of the reasons that we have some of the worst performing governments in Africa is because somebody comes in and spends 4 or 8 years. He has an idea of what he wants to be. Another person comes and he thinks by following some of those ideas, it means he's less of an administrator. And then he clears all those ideas and then he starts his own. There isn't a continuity in terms of progress and projections. And when the new person stays there for 4 years and he goes, another person comes in and he starts something new. Right up to the time somebody came one day and said secondary school should not be studying history. One of the craziest things I ever had in my life. So jurisprudence has to be treated as a heritage, something that is being passed down. And another thing it must do is that it must be functional. It must attach to things, attach to arguments, attach to facts, attach to issues that are happening in our jurisdiction. And we have to learn again from other people's jurisdictions. While we can say it can be abstract and all that, but our discussion, for example, on plea bargain now, using jurisprudence within the jurisprudential context, has shown you that jurisprudence is not as abstract as people think it is. Because in our discussion, we understood what we were supposed to discuss. We were supposed to discuss the nature of plea bargaining. We were supposed to discuss how it is administrated, how it is executed. We were supposed to discuss the purpose of plea bargaining. And the moment you go through that gamut of thinking, then it means that it is not as abstract as people think it is. And as with plea bargaining, it is the same way with every other aspect of our law that you can think about. Even some institutions, the prison system, for example, what is the nature of the prison system? What is it there for? When you say somebody committed a crime, in the Netherlands, for example, they treat all this taking narcotics and all that as a social ill rather than a crime. And the focus was, let us bring in people who are not committing, they are not going around killing people. Some people are smoking Indian hemp, and some are taking cocaine, and some are taking regulated drugs and all that. So for people that are trying to be rehabilitated from cocaine or heroin, for example, we can take them to specific cafes or centers where they buy legal drugs. And if they are not trying to distribute themselves, then there's no problem. In some other places too, we can give people placebos, like, is it methadone for people that are into heroin or cocaine or whatever. It's not heroin or cocaine, but it gives you the same feeling, and it is legal. And because they did that, all the people that were breaking into people's houses, to steal, to rape, sometimes to murder, because they are drug addicts who are looking for what, and then once you are into addiction you fall prey to people that are in the underworld, racketeers and all that. All those people disappeared. Why? Because the judicial system was now able to recognize that this is a social problem rather than a social problem that is spiraling into criminal and legal problems. And that can only happen because of the study of functionalities, how jurisprudence looks at law in a functional manner. So we talked about what was the analytical, the sociological, and the study of development and all that stuff. And then there are two types of jurisprudence. There's something called global jurisprudence. That is what you hear from people like Salmon, the other great writers who talk about jurisprudence globally. But you must understand, like we just said, there's something that is African jurisprudence. There are all kinds of jurisprudence from different jurisdictions. There's Jewish jurisprudence, there's Islamic jurisprudence, not just Islamic jurisprudence, you can have Maliki jurisprudence, you can have Sunni jurisprudence within Islam itself. You can have Hindu jurisprudence, Buddhism has its own, all kinds of things. So don't just look at jurisprudence from a global perspective. You have to look at it again from a local perspective. And in trying to evolve theories, and we talked about what is the importance of theories traveling well. If you evolve a theory that basically says, let's take a look at this Catholic theory that talks about one man, one woman to the exclusion of all others for the duration of their lives. It's something that became specific to that particular way of life. And there are reasons why. Why? Because there was an evolution that says so and so is more important than so and so. And in Islamic law, for example, under the Sharia, where you have you can marry up to 4 wives and all that, it is also because there are certain things that are so important than other things. Which is why you can't have a global outlook for too long. You can study global, but localize the evolution of your thinking. So there are other things that should interest us. Things like, what is the importance of theories traveling well? If you have a theory and you say this theory is a universal theory, it must mean that if you operate it in the US, it should work. if you operate it in Nigeria, it should work. Things like human rights, for example, the right to privacy. All those things evolved from theorizations by people before they became physical law engraved in things like constitutions and other local laws in countries. So it's important that we have this understanding. And when we talk about universal jurisprudence, because in Africa now our focus is, we've always looked at the world, what people call the more advanced nations, the global north, for leadership. Do you think we should be looking at the global north for leadership? Hello?
Sir,
Hello, sir.
we are here.
I do not believe that is
Hello, sir.
possible, sir. Because we
Hello.
have different ideas of leadership.
That we should not be looking at the developed countries for leadership.
Actually, I would disagree with Shumope Abdurrashid on that and say, I think we can't use one like huge stroke to cover everything. It depends on from which aspects we are talking about leadership that we are looking to them for.
Okay, so what you are saying, it depends on what kind leadership from where, right?
It depends on, yes, sir. It should depend on the perspective of which area we're talking about. Because if we're saying generally, that means we're just taking it in every sense of the word, leadership.
Yes, yes, yes.
Okay, now should we be looking for social leadership in terms of how we interact with each other?
Yes, sir. Hello, sir.
Hello, will social leadership...
I believe in whatever sense we are looking at leadership, it is not possible to have a generally acceptable law to guide it. We always have our differences, and that's where in a bit us having.
Okay, now we said we can always have our differences. Now, when we make some rules, because part of the problem is there are certain things we have to understand. We have to understand the interaction of law with what is happening, the interaction of law within our jurisdiction, and just stop looking at Nigeria as Nigeria or a Nigerian legal system. Things change in the world, and we have to have an awareness of how things change in the world. Let me give you an example. One of the things that after the Beijing conference, which was supposed to be a conference where women came together to talk about women's rights and issues relating to families and all that. And one of the things they came out with was that monogamy was the preferred system of marriage at the time. AIDS was a big scourge across the whole world, particularly sub-Saharan Africa. And one of the things they came up with was that monogamy was the preferred marriage system to stop the onslaught of HIV infections. How many people believe that?
I don't believe that, sir.
Who has
Yeah, I
a
don't
different
believe
view?
that too.
Now, why this discussion is important is you have to understand when other parts of the world have an ideology that they are trying to impose on your legal system or social systems. If, for example, you say, okay, a lot of jurisdictions, you find out that men are probably less in number than women. Somebody said in the United States, for example, if every man were to marry a woman in the United States today, there will still be about 2 million women on the waiting list, waiting to get married. Now, what do you think those 2 million women are doing? Engaging in some kind of polygamy, but this time it is not recognized by law.
Exactly, sir.
Or better still, they can marry themselves.
That is already ongoing.
Exactly.
You know, but the key thing is, for the ones that are heterosexuals there, they are still attached to what they will still be attached to one man or the other who is already married to somebody else. Will that not cause HIV infections to rise? So in our situation as lawyers, particularly when we are interested in jurisprudence, we must have an understanding of our relationship as a people, as a continent, with the rest of the world. And because of that,
apart from that, it may also even cause social disturbance.
It can cause a lot of social disturbance. That's true. Because that is where you start having all kinds of abhorrent social behaviors. So we have to know what our place is in terms of international economics, international politics, and law. And stop behaving as if our country is the only country in the whole world. There's an interrelationship, even in terms of how funding for certain things are given. And obviously, we have a beggar continent anyway, where you have conditions based upon which money you are giving for what purpose. So, there are also some other discussions that you could have at your own time, such as whether jurisprudence is the same thing as legal theory, whether it's the same thing as philosophy, whether it is the same thing as empirical legal studies, whether you can interchange these things or not. You have to do your own study, take a look at what jurisprudence is, what legal theory is, what philosophy is, what empirical legal study is, and then whether they are the same or they are different and they have different characteristics. And we said there are two types of understanding law. There's the strict way of understanding law and then the soft way of understanding law. For the second semester, when we start having our discussions, we'll take a closer look at how these are represented from the perspectives of the different schools of jurisprudence. Now, for this semester, and I'll just go quickly through what I'll be teaching you. I'll be teaching you the sources of law and how the application and the role of those sources of law. So basically, two very wide topics that may be like one topic. Now, when we talk about the types of sources of law, we will study what we call the legal source of law and the historical source of law. But for simplicity, a legal source of law is a law that is, for the time being, in force. While a historical source of law could be any kind of source of law that is only persuasive in character. I'll give you an example. If Jeremy Bentham wrote something in a book and that is cited in court, it becomes a historical source of law. But legislations that are for the time being in force specifically will be legal sources of law. Now, and we say Again, the English legal system recognizes 4 basic legal sources. One is legislation, then you have a judicial precedent, customary law, which I'm sure you know that first 3, then conventional law or agreements. Conventional law basically will be talking about laws that are implied. For example, without any written agreement with an agent will probably collect 10% finder's fee for getting someone to help you sell your house or buy your house and all that. Those are the kind of things that are conventional. But obviously, those things can be varied by specific agreements. So we'll go through those. And under legislation, we'll also go through the kinds of subordinate legislation. We have colonial, executive, municipal, judicial, and autonomous legislation. Then from there, we'll discuss the relative merits, the advantages and disadvantages of legislation as a source of law. From there, we now go into interpretation of statutes, which is an area I particularly like, because I always tell you people that the only thing you do as lawyers is to interpret laws. That interpretation can come out in terms of how you draft a will, for example. The way you interpret law comes in terms of how you advise your mega international company in terms of how to pay tax and how not to pay double taxation. Everything a lawyer does revolves around interpretation of statutes. And because that is so integral to our work, there is a lack of awareness that it is still there, and that there are specific skills you require to interpret statutes. So we'll go through interpretation of statutes, and we said there are 2 basic types of interpretation. You have the literal or the functional or liberal interpretation. Then we'll go through certain standards for interpretation, how some specific words, how you interpret some specific words based on certain principles, like the jus dem generis rule and all that. Then we'll also look at, for example, the kind of defects you can have in drafting, where you must now interpret in a particular manner. We call things like semantic ambiguity, you have syntactic ambiguity, and then you have vagueness. And sometimes you just have plain absurdity, where, for example, you may have to require some other kinds of rule, like the golden rule of interpretation, where sometimes the judges actually have to redraft a rule within a legislation. Then when we are done with that, we go to the mischief rule, what is called the Hayden's case. And we found out that the Hayden's case basically talks about where there was a law or a principle before and a new legislation comes into play to take care of a mischief that was unearthed before. Then you now have to ask yourself, how do you interpret this particular new law in relationship with the other law? And what are the elements that you look at and that must be taken care of? And these are the 4 elements. What was the common law or law before that time? What was the mischief or defect and all that? And then we also found out that right now there are issues relating to how the Supreme Court is beginning to interpret these things. When we say the common law or law, do we mean customary law? Is customary law included? We'll have that discussion too. And then we can have things that what are the remedies provided, the reason for the remedies. From there, we go to judicial precedents, where we will ask ourselves, what do you think about judicial and how can it be applied in its strict sense, in its loose sense? What are the distinguishing techniques in terms of when you are using this double tripod of judicial precedent and stare decisis. Then important to judicial precedent is we talked about the hierarchy of cause, stare decisis, and then we also talked about ratio, things like ratio decidendi, how you come to isolate the specific elements of a case. How do you get there? You have the material facts test, you have the reversal test, and there are other tests. For some of you that will get employed in law firms where publication of law reports, if any of you had been employed while Chief Ganifa was alive in his law firm, a lot of the things you'll be doing will be publication of law reports. So it becomes very important for you to understand these tests where you can isolate principles and the decisions that the judges made in respect of those specific principles. Then how precedents may be avoided, distinguishing between ratio, decidendi, and obiter dictum. All of us know obiter dictum means statements that are made by judges by the way and may not specifically touch on the facts or the facts tied to the principles of that particular case. So they do not form the ratio of the case. They are just in terms of, they can be persuasive, it can be advisory, it can be anything, but they do not form the ratio. Then obviously advantages, disadvantages. Then we go to customary law, which is good because you must have done that in Nigerian legal system. So the amount of work we'll do there may not be as profound as some of the others. Again, we will talk about conventional law and agreements. I think a few sentences here and there should take care of that. Then we talk again of applications of the sources of law, which is supposedly the second topic that will be taken, but still has relationship with the sources of law. And when we do that, we will also be discussing things that are considerations when you're applying law, things like logic. Under logic, what is deductive reasoning? What is inductive reasoning? We'll talk about analogy. We'll talk about public policy, which in Richardson and Merlich, they said public policy is an unruly horse that can take you anywhere. Why? Because public policy changes over time. So when judges use public policy as a crutch to try to interpret the law, it can sometimes be very problematic. So we'll have that discussion. And then we'll go to inhibitors to accurate decision making. Why? Because you are making decisions all the time as a human being, particularly as a judge. And there was a study by somebody and a group of researchers headed by somebody called Guthrie, where they went and tried to isolate some of the things that can make you not think rationally or logically as a judge. And those were things that they said were inhibitors. And they said the first one is anchoring. We'll have that discussion. The second one is framing effects, hindsight bias. Anchoring basically is when someone just says, for example, in a compensatory issue in court, and somebody insulted my reputation. And for damages, I'm asking for 1 billion naira. How many of you think my reputation is worth 1 billion naira?
I think you're.
You think so?
Yes, sir.
Aisha, thank you. You made my day. I feel much better now. So when we talk about anchoring, for example, what lawyers do is to just put an anchor because you don't know the value of it. And I do not know the value. Nobody knows. It's what I say it is. And in making a decision as to what damages should be avoided for libel, for example, the judges, your mind plays games with you. If someone says 1 billion, you'll be thinking, okay, if I say 700 million, it is still closer to 1 billion. Whereas my own reputation, if somebody insults my reputation, I will take 1 million from anybody and pocket it and thank him and have a nice day. But that is not the way inhibitors work, so that you don't arrive at accuracy in judicial decision, is that you don't know the value. You have to use that anchor, that 1 billion, as a starting point for your reasoning. So again, there's a framing effect. Framing effects basically will be that if somebody is in losing position, does he want to go to court? If somebody is in a winning position, we hear accept less, we hear accept more. Then hindsight bias, we'll go through representativeness, heuristics, egocentric bias, and other cognitive things, such as economics, financial status. In Nigeria, for example, tribe, religion may play some very big roles in decisions that judges make. So we go through all that, and at the end of the semester, we try to review again and see what we can come up with. If there are any questions, we'd love to hear it and see what we can do.
No question.
I have a question.
Go ahead.
Yes. Because following the class, right, where we're talking about jurisprudence, but particularly where we're talking about law, right, the nature of law and amongst other things, I noticed something very peculiar about how we were interpreting the law, and that is we're interpreting the law within the context of domestic law. Because I feel like if we were taking that as an interpretation of law in general, for example, saying that law must have some form of governmental response to its violation or breach, this would kind of be, in a way, ignoring, I don't know, international law. So I wanted to ask if within the context of law for this class, we would be focusing on domestic laws alone.
Well, my response to that will be there are 3 lecturers that will be teaching you. Some will be teaching it from the perspective of concepts and all that, which will have an international and comparative content. Now, for this class, most of what we'll be doing will be mostly, the topics we are talking now will be mostly domestic law, but with comparative components. Now, we can't go full into commercial law, even though we will be treating the areas of commercial. Second semester, for example, you'll be talking about the schools of jurisprudence, right? And then you will find out that natural law, Hugo Grotius is called the father of international law. So natural law, basically, the whole idea of the social contract theory as expounded by Hugo Grotius did not just talk about social theory as, the social contract between citizens and leaders as in its domestic terms alone. It also talks about it in its international relevance. Then you find out that the positivists do not even look at international law as something of a law form. Why? Because the way they look at it is it does not have specific sanctions and all that. So what we're talking about is you have to look at it within context.